Good afternoon, friends. In this video, I will talk about one of the latest judgment which is given for a reference which was kept before the Honorable Supreme Court by DV due to some clarity for the Maintenance Act, Hindu Marriage Act. Honorable Supreme Court on 12th February 2025, answering a reference, ruled that permanent alimony and internal maintenance under the Hindu Marriage Act 1955 can be granted even when the marriage has been declared as void. This is the answer to reference. How it happened, I am going deep into that. A spouse whose marriage has been declared void under Section 11 of the 1955 Act is entitled to seek permanent alimony or maintenance from the other spouse by invoking Section 25 of the 1955 Act. Whether such a relief of permanent alimony can be granted or not always depends on the facts of each case and conduct of the party. The grant of relief under Section 25 is always discretionary, the Honorable Court said. Regarding the grant of interim maintenance under Section 24 of the Hindu Marriage Act, the court observed, even if the court comes to prima facie conclusion that marriage between the parties is void or voidable, pending the final disposal of the proceeding under Act 1955, the court is not precluded from granting maintenance pendent provided the conditions mentioned in Section 24 are satisfied. While deciding the prayer for interim relief under Section 24, the court will always take into consideration the conduct of the party seeking the relief, as the grant of relief under Section 24 is always discretionary. Honorable Bench comprising Justices Ave S. Oka, Ahsanuddin Amallah, and Augustine George Missy delivered the ruling in response to a reference made by a two-judge bench led by Honorable Justice Bikram Nath last year. The reference was prompted by conflicting Supreme Court decisions on the question of whether permanent alimony or maintenance can be awarded to a spouse even after the marriage has been declared void under Section 11 of the Hindu Marriage Act. Section 25 of the Hindu Marriage Act provides discretionary power to the family court to grant permanent alimony upon passing of any degree under the Act. The husband appellant contended that the term any degree under Section 25 of the HMA should not include degree declaring a marriage void. He argued that a void marriage is legally non-existent, so no spouse can claim benefits under Section 25. For brevity, as per Section 11 of the HMA, marriage is declared void if there is an element of bigamy, spouses are within the prohibited degree of relationship, or parties are spinda of each other under Section 5 of the Act. Rejecting the argument presented by the husband appellant, the judgment authored by Justice Oka underscored that a degree of nullity declaring a marriage void still qualifies as a degree under Section 25 of the HMA, allowing a claim for permanent alimony. While enacting Section 25, Subclause 1, the legislature has made no distinction between a degree of divorce and a degree declaring marriage as a nullity. Therefore, on a plain reading of the section 25 subclause 1, it will not be possible to exclude the decree of nullity under section 11 from the purview of section 25 subsection 1 of 1955 Act. The Honorable Court reasoned. The court answered the reference accordingly. Also, from the judgment, calling a woman legitimate wife or faithful mistress violates its rights. Supreme Court criticized this language in judgment. So, the details of the case are Sukhdev Singh versus Sukhveer Kaur. You can go to citation 2025 Live Law, Supreme Court 195. This is all about today's video. Enjoy your life. Good evening. See you again.